Will you commit to publicly providing the unredacted version of this so that the American people can understand the extent of Donald Trump's lies about his relationship with Jeffrey Epstein?
You're about as good of a lawyer today as you were when you tried to impeach President Trump in 2016. Have you apologized for that in 2019?
So will you unredact this? Will you
were
unredact
lead
this?
counsel on that. Privileged.
I'm asking you, will you unredact this?
Privileged.
This may look like another heated congressional exchange, but it's actually a test of transparency in one of the most sensitive federal investigations in recent memory. What's really being tested here is whether executive authority can control public access to politically consequential evidence. When document redactions intersect with elected officials and ongoing oversight, it raises broader questions about neutrality, disclosure standards, and institutional integrity. In this video, we'll break down how a dispute over a single email evolved into a larger confrontation over accountability, redaction policy, and the balance between Congress and the Department of Justice.
New York recognized.
Thank you, Mr. Chairman. Ms. Bondi, I went over to the department yesterday for a couple of hours to review some of the unredacted materials. And I am looking forward to your detailed explanation for why you have withheld almost half of the documents, which is required by the bill. Now, obviously, there are 3 million documents, so I didn't get through much. But one thing I didn't see was the client list that you said you had on your desk a year ago. I did, however, find a couple of important documents: an 86-page prosecution memo from the Southern District of New York and a draft indictment from Florida against Jeffrey Epstein's co-conspirators. For reasons that I cannot understand nor are permitted by the bill, they were still redacted, even for members of Congress. So, Ms. Bondi, will you commit right here to immediately providing those two documents in unredacted form to members of Congress? Not a complicated question.
Well, I guess it is for you because you have a law degree and those are privileged.
Okay, they're not privileged, but we will discuss that later. I also found an email that I have right here from Jeffrey Epstein to Ghislaine Maxwell that was unredacted, and it included notes of statements that Donald Trump made about his prior relationship with Jeffrey Epstein. Now, there is no reason for this to be hidden from the American people. There is no privilege, there is no attorney-client privilege, and I see you're checking with your staff, and I can assure you, staff, this is not under attorney-client privilege because it was sent from Jeffrey Epstein to Ghislaine Maxwell. Will you commit to publicly providing the unredacted version of this so that the American people can understand the extent of Donald Trump's lies about his relationship with Jeffrey Epstein?
You're about as good of a lawyer today as you were when you tried to impeach President Trump in 2016. Have you apologized for that in 2019?
So will you unredact this? Will you
were
unredact
lead
this?
counsel on that. Privileged.
I'm asking you, will you unredact this?
Privileged.
Privileged, of course. I look forward to discussing this more. Now, these are obviously improper redactions.
And let me stop for a minute.
I'm talking.
If they're not privileged,
quiet.
Don't yell at me. If they're not
Mr. Chairman, would you stop the clock? This is on your
privileged-
time. It's not on Mr. Goldman.
They're not
Even though you
privileged,
used your
if we review
improper
them and they're not-
redactions
You'll like my answer.
to
If we
continue
review
to
them and they're not
protect
privileged,
Donald
Time belongs to the
we will
member.
be happy to release them.
We'll stop the clock. We'll stop the clock. Time belongs to the member. Go ahead.
Even though you used improper redactions to protect Donald Trump and other predators associated with Jeffrey Epstein, you did the exact opposite thing with the survivors and victims of this scheme. So their identification information was really the only thing required to be redacted, and it was not. And it's clear this was not a mistake. This was not by accident. This was not because you only had 30 days when you really used 75, and that doesn't even include all the hours last March that you were redacting it. But I'll tell you why it's clear it wasn't a mistake. There is an email entitled Epstein Victim List. There are 32 names. One is redacted. 31 are not. So someone looked at it and decided to redact something. And I will tell you that that is clearly intentional to intimidate these survivors and victims. Now, in an interview last week—
How will you tell me that's intentional?
In an interview last week, Deputy Attorney General Todd Blanche—
You can't go off script.
—said that any victim that wants to speak with the department has done so, hopefully. Well, thanks to the incredibly brave people sitting here behind you, we can actually ask them if that's true. Now, would the survivors and victims who are here please stand up one more time? Just by show of hands, how many of you or your loved ones actually have met with the Department of Justice and provided testimony and evidence? None. And of those of you who have not met, which is everyone, how many of you have reached out either individually or through a lawyer or representative to offer to provide testimony and evidence? All of them. And of those of you, all of you who have reached out, how many of you were denied or ignored by the Department of Justice? All of them. And despite the shameful and despicable efforts by Ms. Bondi and her department to intimidate you, how many of you are still willing to speak to the Department of Justice? All of them. Well, Ms. Bondi, it looks like you have some more witnesses to
Gentleman's time has
talk
expired.
to, and I yield back.
We will go to the good gentleman from North Carolina, Congressman Knott.
Thank
May I
you.
have a moment, Congressman?
Yes, ma'am.
Thank you. Here we go. Here's the photograph. This is why he wanted to repeat everything that had been said previously on Epstein. This is his state, New York. You probably don't even know who this is. Wahid Mohammed from Afghanistan.
Yes, because I'm no longer a prosecutor.
Convicted of assault. Wow, he represents New York. Wow, yet he doesn't care about the illegal aliens convicted of crimes. Assault and homicide. No longer a prosecutor, so he doesn't care about his constituents. Here we go. Arson, El Salvador, Miguel Palacios. Fermin Flores Ramales, Mexico, rape.
Let's talk about the 70% of immigrants who are detained without
Time.
a criminal conviction or arrest.
Stop the clock. Stop the clock. Time belongs to Congressman Knott.
The hearing reached its breaking point the moment Representative Dan Goldman held up that email. In a room already charged with tension, he described what he had found inside the Department of Justice. An unredacted message from Jeffrey Epstein to Ghislaine Maxwell containing notes about statements made by Donald Trump regarding his past relationship with Epstein. It was not whispered. It was not vague. It was specific. And he asked a simple question. Why is this still hidden from the American people? Attorney General Pam Bondi's response did not clarify. It deflected. Privileged, she repeated, as Goldman pressed her to commit to releasing the document in full. And that exchange, sharp, personal, escalating, was about more than a single email. It was about transparency in the face of power. Goldman had just returned from reviewing millions of pages of unredacted material. He said nearly half of the documents required by law had been withheld. He pointed to an 86-page prosecution memo from the Southern District of New York, a draft indictment from Florida, redacted even from members of Congress. He questioned the absence of the so-called client list that Bondi had previously referenced, but then came the moment that shifted the hearing from procedural dispute to moral confrontation. He turned to the survivors seated behind him. He asked them to stand. One by one they rose. He asked how many had been offered the opportunity to meet with the Department of Justice. None had. He asked how many had reached out to provide testimony. All of them had. And how many had been ignored or denied. Again, all of them. In that instant, oversight became human. The argument over redactions collided with the reality of lived experience. And the hearing exposed a central contradiction. Documents redacted to shield powerful names, while identification details of survivors allegedly remained visible. Goldman framed it as intentional. Bondi pushed back. The chairman struggled to maintain order. The clock was stopped and restarted. Voices overlapped, but the cameras kept rolling. This is the architecture of American accountability. Imperfect, contentious, loud. Congress has the authority to question. The Department of Justice has the authority to prosecute and protect privileged information. Yet when those authorities clash publicly, the American people are left to decide whether the system is functioning as designed or whether it is bending under political gravity. The mention of Donald Trump's past relationship with Epstein is not new to public discourse, but in this hearing, it was not speculation. It was anchored to a document. And Goldman's insistence on unredaction was not framed as partisan spectacle. It was framed as a test of equal application of the law. What is privileged? What is political? What is being shielded? And why? Bondi's sharp remark about Goldman's past impeachment efforts signaled how quickly oversight can devolve into personal history. Yet even that response revealed something about the modern state of governance. Hearings are no longer confined to sterile legal debate. They are arenas where past battles echo through present confrontations. Then, as the exchange moved forward, the subject pivoted, from redactions to immigration enforcement. Bondi held up photographs of individuals convicted of serious crimes, tying them to New York and questioning Goldman's priorities. Goldman countered with statistics about detention rates without convictions. The clock was stopped again. What unfolded was not a tidy legal seminar. It was a collision of narratives: public safety, prosecutorial discretion, survivor testimony, executive authority. And through it all, one theme persisted: who is the system built to protect? When survivors say they reached out and were ignored, that is not a partisan talking point. It is a challenge to institutional credibility. When lawmakers say documents required by statute remain withheld, that is not simply a procedural disagreement. It is a referendum on compliance with the law itself. The United States built its constitutional framework on separation of powers, ambition countering ambition. But that framework only works when transparency and accountability are not selective. In that hearing room, the stakes were not confined to one administration or one official. They touched the deeper question of whether justice is insulated from influence, whether powerful names receive procedural caution that ordinary citizens do not, whether survivors seeking acknowledgement encounter doors that open or remain closed. The images of those standing behind Goldman may fade from headlines. The redactions may eventually be debated in court filings and legal memoranda. But the memory of that moment, the simple act of asking them to stand, will linger. Because democracy is not measured solely by statutes passed or indictments filed. It is measured by whether institutions respond when citizens seek to be heard. The exchange between Goldman and Bondi was heated. It was imperfect. It was raw. But it was also a reminder of why oversight exists in the first place. Not to score points, not to replay old grievances, but to ensure that the machinery of justice operates in the open. The American experiment depends on that openness, on documents that withstand scrutiny, on officials who answer difficult questions without retreating into ambiguity, on lawmakers who persist even when the room grows loud. In the end, the hearing did not resolve every question. It did not produce immediate disclosures. It did not calm the divide, but it revealed the tension at the heart of power, between what is known and what is withheld. And that tension is where accountability lives. Stay informed. Stay engaged. And if you believe transparency matters in moments like this, subscribe to Liberty Report USA. Support our work as we continue to follow the facts, ask the hard questions, and examine the decisions that shape our system of justice.